Good morning once again. My name is Scott Ehlers. I am a policy analyst at TIDC. I just came on in December. The topic at hand right now is managed assigned counsel programs with a focus on Lubbock and Travis counties. This is one of my favorite topics in indigent defense, not only because I think it's a great model that lots of counties in Texas can implement to improve the quality of indigent defense, but also I started as a solo practitioner here in Travis County, working under the Capital Area Private Defender Service. I was immediately totally impressed with their operations and what they were doing and how they helped me out as a brand new lawyer to know what was going on and make me a better lawyer. And also, I must mention this publication that I've been working on for many months now called the Primer or Primer on Managed Assigned Counsel Programs. You can find many copies of those back there. If you're interested in learning more about MACs, starting one up, etc., I highly recommend you start with this. We are working on finishing up a supplement as well that's going to go in a deep dive on Lubbock, Travis, and there's also Collin County has a MAC, the Mental Health Managed Counsel Program. Elise Ferguson from Collin County will be speaking on the mental health panel a little later and talking about her program. We've got Bradley Hargis here today. He's the Deputy Director of the Capital Area Private Defender Service here in Travis. Kelly Bailey is a criminal defense lawyer. She was my mentor in the CAPD's program. I would not have known what I was doing without Kelly. So I thank her once again. Bradley as well. This guy, like, he probably really got annoyed with me coming around time and again asking for information about driving offenses. I don't know if you know the traffic code and driving offenses. I think those are like some of the most complicated cases that I ever came across. Cliff Brown, the Judge Cliff Brown, he's a district judge here in Travis County. And Phil Wishcamper is the interim director of the Lubbock Private Defender Office. I think y'all have heard that Jim Bethke will be going over to take over the director position, and Phil will be moving over to the what he really loves to do, I think, is being the professional development guy. So without further ado, we're going to start with Travis County. Bradley is going to start things off, and I think there's going to be a little bit of a discussion about some of early days of CAPDs and how they started the program up. Bradley?
Okay, so our journey started like very many people did. Our system wasn't very different than the vast majority of all counties and much of the country until very recently. We had developed, post-Gideon, like every jurisdiction, a solution. In the 80s, Travis County actually started to implement a wheel, which many of you will be familiar with now because in 2001, thanks to Senate Bill 7, a rotational assigned system, or a wheel, as most people know it, became one of the options for jurisdictions to use statewide. It was by and far the most common model. So, but we're going to go into a little bit about why we tried to change that or decided to change that. But in 2011, we went with a new option exploring that, which is managed assigned counsel. And let's talk a little bit about that, and then we'll get into some of the real issues. All right, so the 2011 process was very similar to what most of you know. The judges were approving the applications, they were determining the appropriate list, they were appointing from the list using a rotational system, which was partially functioning. The list worked well, but many of the cases, because of some system design issues, were still being assigned from the bench. Judges set the fees in the fee schedule and approved all payments individually for attorneys, most frequently right there at the bench, approving vouchers being submitted by attorneys. The judges conducted an annual review of the attorneys and set the standards for performance and CLE, so probably what many jurisdictions are familiar with. From most of you will know that doesn't necessarily meet all the best practices or the ABA 10 principles on a public defense delivery system. We met many of them, but we missed on several, and that's what we're really going to talk about now. So I want to turn it over to Judge Brown. He's going to talk a little bit about why we changed.
Right, and so thank you all for being here, and we're excited to be here as well. But probably about 6 or 7 years ago, one of our senior district judges who retired by the name of Mike Lynch, he was the impetus behind this program getting started. And so one of his biggest struggles was the fact that we weren't abiding by the number one. Forget about the 10 principles, just start at number one, and that is that the indigent defense function be completely independent of the judiciary, and it just wasn't that way. And so it was problematic for him, and he began to push to explore other ways to do things. And so one of the biggest things is, we not only selected the attorneys, we did the payments, and it was almost a situation where it just seemed unethical, really, because there is a negative perception, if you will, anyway, concerning the delivery of indigent defense. And so the idea is that somehow indigent defense is subpar to a private attorney, and that simply is not the case. And so we have some of the best attorneys in our county on our indigent defense panels. But the perception was fed when you are, as a judge, on the bench, and when a plea is done, you are then immediately filling out a voucher that's provided by the defense counsel in front of the defendant, oftentimes, most times actually, and it almost feeds into this idea that, persons are paying for a result or just paying to get the case down the road, and it just didn't feel right. And so that has been one of the biggest things. The other thing is in terms of the size of the function. We probably at the time had over 250 attorneys on the appointment list. And so there are 9 district judges, or 8 now, soon to be 9, but it was too overwhelming to have our arms around the entire system to supervise folks, to really make sure that people are doing their jobs the way they should be doing their jobs. And so it really is problematic. And one of the bigger things, and I think we'll probably get into it down the line, but the truth is that it is hard for a judge to delve into, and I think inappropriate for a judge to delve into kind of strategic decisions by defense attorneys in terms of the appointment of investigators, experts, and what have you. And so I felt like we find ourselves kind of getting involved where we shouldn't be involved. And so that was a big impetus behind making this change. The other thing is that, and I think the biggest thing was in terms of the compensation. And so because you had so many judges involved in paying attorneys for the work that they've done, and it was inconsistent across the board, quite frankly, in terms of what was being paid by different judges to different attorneys for the same thing. And so that was one reason we had to make the change. And I think that you'll find out throughout this presentation that things have improved a great deal. And that was one of the biggest sources of discontent or controversy between lawyers and judges in terms of the payment. And I kind of feel, and I know my colleagues feel, that we shouldn't be involved. We're not involved in how the DA gets paid, so why should we be involved in how a defense attorney gets paid on a case? And that has taken a lot off our plates. And I think it presents for the public a better perception of how justice is meted out.
Thank you. So, as Judge Brown said, Judge Lynch started us also on this journey and got a series of stakeholders together to really start talking about what were our options to improve it. The first thing that Judge Lynch was putting on the table was a managed assigned counsel. program. So there were some conversations about, can we make tweaks to the existing unmanaged assigned counsel system? There was the conversation that Judge Lynch had brought forward on a county agency-based model. There was also a conversation about a private defender model, and then also a conversation about, should Travis County be moving towards a public defender? And so these were all part of the conversations, and I think any county looking to reform or modify or improve the delivery of indigent defense will have to go through some version of these permutations to decide what the right step for your community is to make in that moment. So just take you through the expiration a little bit. In fall of 2012, it kicked off with the judges. Judge Lynch had the district and county judges vote to explore options for a MAC, and we began a series of collaborative meetings. There were over 100 meetings that occurred with various groups and subgroups between different stakeholders over many, many months, really years, to get the process going. We really got energized when we did a site visit to Lubbock to see their managed assigned program, because in May of 2013, when we were considering, Lubbock was already operating. So we went and saw and learned a lot about what managed assigned could be there. And then I think we really got on track when we went in October 2013 to San Mateo, California. For many of you have probably heard of San Mateo. They've been doing managed assigned for over 30 years there. So they're kind of the grandparent of managed assigned. And so we went and saw a very mature, very well-developed system there. And so when we came back from that, I think a lot of the stakeholders were really convinced that this could be something that might work for our community. One of the steps we took was to get the wider bar involved. So up to that point, we'd really been working with the criminal bar, the criminal indigent defense community. But we got the Austin bar, which is for, in our community, mostly the civil bar. We have kind of a bifurcated bar almost. And so we got the civil bar involved as well. And their leadership was very instrumental in being involved, bringing a larger picture of the legal community. And they understood that even though many of their attorneys don't practice criminal law, that the community at large has the responsibility to meet Gideon's promise of having attorneys there to represent clients. Whether you're a civil attorney or a criminal attorney, you bear part of that responsibility. So the judges approved to pursue a MAC grant through TIDC, and we determined the best way to keep what we like and improve what needed to be improved was a private defender model established through a nonprofit. So I'll briefly tell you about how our nonprofit works, just to give you an example. Phil will be able to tell you about how a different model of his worked. They didn't go with a county agency, they went with the Bar Association. So for those of you not familiar with the statute, you have essentially three options for how to structure a MAC. You have a county agency model, you have a nonprofit model, a 501c3, which is what we are, and then you have a Bar Association model, which probably is also a 501c3, but specifically a Bar Association. So those are the different agencies that you can choose to house the managed assigned function in. So ours is a joint venture nonprofit between the Austin Criminal Defense Lawyers Association and the Austin Bar, supported by the Travis County Judiciary, and the Texas Criminal Defense Lawyers Association also supported it. This is our structure, and I'll go briefly through it just to give you an idea of kind of who the key players are. We have a board of directors like any nonprofit. They have a fiduciary duty, oversee the operations of a MAC. We have an Oversight Committee, which is the committee that we interface with from the county. I'll tell you briefly about the makeup of these in a moment. Then we have a director, which is very similar to the Lubbock model. We have an executive director. And we also have a review committee, which is another option the statute provides. So when you're deciding to set up a MAC, you can either invest the power to make decisions into a single person, or persons perhaps, but it comes down to the executive director making a decision. Or you can establish a review committee. The statute provides for that as well. And we chose to establish a review committee. After that, we have, of course, like any organization, you've got deputy directors, attorneys focused on mentoring. We've got a holistic team and administrative staff, and that's what we have. So briefly, board of directors, as we talked about, basic operations, oversight, county leadership, and review committee is a panel of experienced and respected attorneys from our community that are making the decisions about who is on and off our panel and what level they get to participate in. So I won't take you through the details really of how our board is established. Just suffice it to say it is a combination of all the stakeholders having influence on our board. So the Austin Bar is placing people on our board, the Austin Criminal Defense Lawyers Association placing people on our board, and the judiciary is placing a retired judge onto our board to make sure that all voices are being heard and represented. And we also have 2 public members that are voting members in their full right from the community, and those are drawn from community groups that have a real interest in seeing quality indigent defense and have passion for the function. So we also have non-voting board members, which we thought were really important to make sure we include members from our panel. So obviously there would be a conflict for them to actually be voting members, but they attend and have every right to have all the information to be heard on any issues. Kelly Bailey is one of those non-voting board members, so she participates in every function the board does except for voting to make sure that the board really understands and never loses touch with what our attorneys are doing on the board. The Oversight Committee, their basic functions are our interface with the Travis County. So they're our county liaison. They approve our contract or recommend our contract to be renewed annually. They receive our reports, review where we stand in our budget. All those kind of supervision functions or relationship functions between us and the county are handled through the Oversight Committee. And it's comprised of various types of county leadership, including the judiciary. So the review committee is what's different, or one of the things that's different between Lubbock and Travis County. So I'll spend just a minute highlighting that for you, because the review committee is something that you can choose to do in a managed assigned counsel program if you want to. It's authorized by statute. It has to have at least 3 members. Ours is at least 3 to 11 members. We try to keep it as close to 11 as possible, but it is a big time commitment for our members of our review committee. They have to have at least 10 years of minimum criminal law experience. And they act is basically both hearing panels, and then they can sit en banc for if it's necessary. So for all the reviews of the annual review of the list, who's on or off, panel levels, they all decide that together. If there's individual acts or allegations of misconduct or deficiency, the review committee can establish smaller panels to basically meet with the actors, the attorneys, discuss the issues, and make recommendations back to the full review committee about what should happen. The review committee is really a very powerful instrument for our community and our members, because they decide. They have the final say, no appeals beyond them, per the statute. That's it. They make the decisions for our organization about who's on and off the panel, at what level, and if there are allegations of unsatisfactory performance, if the person should be mentored, removed, or otherwise dealt with. One of the things that I'll leave for Phil to talk a little bit about, but I'll mention, is that we did a hybrid model. So in Lubbock and San Mateo, they pretty much fully privatized all the services, including payment and the individual appointment. The entire indigent defense budget is paid directly to those organizations, and then they make payments through their nonprofit. Ours was a larger system than San Mateo and Lubbock, by quite a bit, and so we felt like it might be a little unwieldy to try to take all of that on in the first year. So we came up with something we call the hybrid model, leaving many of the administrative functions with a very well-running Office of Court Administration. This reduced complexity, it reduced cost, and it allowed us to continue to use some very highly effective structure, software, technology that was already in place. So we're making, the Managed Assigned Counsel program is making decisions about who's on the panel and how much people get paid, but the actual pressing the buttons or the daily rotational operational list, the actual cutting of the checks, all of that stuff is still handled by the county. So we pass the authorization or the request to make a payment to the county. They mail the check out to the individual attorneys. That's a little different and provides an option that's maybe a half step between a full privatization. So I'll just talk a little bit more about how it's going, and then I'm going to turn it over to Kelly and others. One of the things that was most immediately seen in our program was the improvement on the fair and neutral part of the ABA standards. Prior to CAPS, we were seeing about 45% bench appointment rate. There's no reason to say that was necessarily unfair, unneutral, the way those were being handed out, but they weren't being handed out in a rotational manner. Judges were using a variety of reasoning about who was available, who was in the courtroom, all kinds of things, but it wasn't purely rotational. So after CAPS took over, we're seeing a bench appointment rate, which the judges still retain the power to bench appoint in our system if they find exigent circumstances exist, but we're finding that after CAPS took over, the appointment functions that dropped to less than 1%, and that has maintained since the inception of CAPS in January 2015. It's actually well below 1%. It's actually below 0.5% now, where we're seeing very few appointments happening every year. And even when you read them, the judges have to, make a finding on the record about why exigency exists. It's frequently things like matching up a case with someone just had a new case added in court, and instead of sending it to us, they're just going to go ahead and merge the two together right there. So we're seeing, pretty much that problem, if you consider it a problem, is resolved. One of the fears that I think every community will face when you talk about changing something about an indigent defense system is the worry about cost. For many communities, or most communities, this is a substantial or a huge portion of their county budget. It is a big commitment communities have to make to indigent defense. And so one of the things that our community was worried about was controlling cost, or if this would drive cost out of control. So I'm happy to say that costs have maintained as predicted and budgeted. The county has allocated more money over time to the project, because I think a recognition has happened with the support of the judges that our attorneys certainly could be paid more than they were being paid. And we continue to work on that, but we have been sticking within budget and right on track. We're also seeing greater utilization of resources now by attorneys. So we see investigative resources are way up. We had under 0.5% utilization and under 0.2% on misdemeanor utilization of investigators, for example. And so we're seeing that percentage way up now. And we're also seeing better outcomes, because one of the things we also do is provide essentially a managed assigned function for our attorneys, or for our investigators. So investigators, in order to take assignments from our attorneys, have to go through some training, work with us, and we offer them continuing educational opportunities. And so we're seeing in dismissal rates, reductions and not guilties are up considerable. So on the data, early data shows that, for example, in district cases where investigators were seeing a dismissed, reduction, or not guilty in 66% of cases where an investigator was assigned, as compared to 30% with no investigator, and 34% even pre-CAPS investigation. So even where investigators were being used before, without the support and the training of a managed assigned program, they still weren't being used as effectively. We're seeing also similar numbers on misdemeanors with 53%, and then is compared to 40%. And so we also have brought a holistic team. Thank you, TIDC, for supporting that effort, and Travis County for being willing to step up and really add something. I know Judge Brown may have some thoughts on the contributions of social workers, but it's been very impressive in our community. We added two full-time social workers and one staff immigration attorney. As MAC was coming online, Padilla was already out there, but it was really heating up, and it became evident quickly that our attorneys didn't have the resources necessary to comply. And I know immigration is one of the topics, so I won't get into that far, but I know many of you will be interested to hear about that, because it is a real issue for our communities.
Right. Let me just jump in here, and I backtrack for a minute on a couple of points. One is with respect to the investigations, and I alluded to it in the beginning, in terms of the judiciary getting involved in terms of approving investigators and experts and what have you. And I've definitely seen the increase, and I think Kelly can probably speak to this, how attorneys are utilizing that a little more. But I think it is working well, because it really wasn't appropriate for a judge to, as the fiduciary, and having the fiduciary responsibility of the county and spending the county's money, but at the same time balancing your role as a judge to make sure the playing field is even and everybody has the resources that they need. But it felt unseemly to kind of get involved into strategic decisions in terms of, how a person is going to present their defense. And so now, with the utilization of the CAPS-D staff itself, being able to assist attorneys in terms of just bouncing things off each other in terms of the strategy, in terms of when you're going to use an investigator, what you're going to use them for, and it's better suited for them to make those kind of determinations than the court, right? Because it feels like you're being involved in the case. And then secondly, with respect to the holistic defense and what CAPSD has brought to bear, in terms of the social workers, the immigration attorney, and I can say that I have seen a marked difference in terms of what is presented to the court. So a lot of times people ask you, attorneys ask you to do things, right? But as a judge, you have to give me a good reason, give me something to hold on to. Why should I do what you're asking me to do? And a lot of folks who find themselves in need of indigent defense, poor people, right? A lot of people don't have families, and you don't see people with people who are there for them as a support system, if you will. And so when it came time for presentation in the event of a conviction for punishment evidence, you know, kind of my thought is that there's always something to say about someone. I don't care how unredeemable they may seem, there's always something to be said. And so I can say that through this program, I've seen so many occasions, too many to mention, where the social worker, regardless of a person doesn't have somebody there for them the entire trial, but they will present evidence of, you know, kind of just the systematic trauma to someone's life in a general perspective, but it is something that they present that relates back to this particular person in their situation, whether it be a social worker, a psychologist, just a practitioner in a particular field, and it really it gives a whole different perspective. And so that has been something that I have seen happen time and again, where I would not have seen things presented in terms of a case for punishment, in terms of what is presented to the court by the defense, and I'm seeing it now, and it makes a difference.
I come to you wearing two hats, both as a defense attorney who accepts court appointments and also as a member of the Capital Area Private Defender Services Board. So I want to tell you that change is hard. So those of y'all who are interested in putting forward a MAC in your county, I would hope you would leave here with eyes wide open. And that's what so I'm not the wet dish rag, but I am here to help you and educate you so you can avoid some of the pitfalls that we experienced. So to say that we had hundreds of meetings is probably an understatement. Bringing in all the stakeholders, and that's the defense bar, that is the civil bar, that's the judges, that's the county executives, that's the county judge, that is the county commissioners, that is purchasing, that is the sheriff, the prosecutors, and convincing them that this is the best way to deliver the best indigent defense was at times felt insurmountable. It was a Herculean effort, and I say well done to everyone here at this table, and certainly to Judge Lynch, who was our champion from the get-go back in 2011. So when I say change is hard, I mean that we have had this culture in Travis County of doing things our way. And our way is, of course, always the best way. Not objective, but it's certainly the best way, right? So certainly an outsider coming in saying, well, you can make some changes, is not always received very well. And it wasn't in this case, except with the exception of some key stakeholders that just never gave up. What you might face if you want to bring a MAC in is resistance from the defense bar. You've got folks who've been receiving court appointments, and you've got folks who are receiving a lot of court appointments. And that's why the statistic that Bradley gave you about the appointments directly from the bench, directly from the judge right there in court is so important. With the reduction of those bench appointments, what you see is a reduction in, dare I say, favoritism. With attorneys who can handle that volume, our fear was that we were in direct violation of the ABA's 10 principles, because you're putting an attorney in a situation where they might be putting their own financial interests above the interests of their client. And to have the judiciary participate in that is like Judge Brown says, just unseemly. And we just didn't want to be a part of it. So with the reduction of bench appointments, what we've seen is a diffusion of the appointments so that you don't have a handful of attorneys working out 300, 400, 500 cases a year, 600 cases a year, and making a ton of money off indigent defense. Not that I don't think attorneys should be compensated, because that's another thing that I advocate for, good compensation for good work done. But there is no possible way, if you are resolving 600 cases a year, and half of which are felonies, that you could be putting the time in that is needed to put forward a proper defense. So that is a huge step in the right direction. So change is hard. So what we've done is worked on changing the culture from within the defense bar, changing the expectations. So lifting the floor up. So like Judge Brown said, we now know what a good investigation looks like. And I credit our deputy directors and our executive director on working with the attorneys, those who are willing to listen, and even those who weren't because they had to attend a mandatory training, on what a proper investigation looks like. And as a result, a couple of things have happened. One, they've educated us. This is what a proper investigation looks like. And although we have blown our budget on that, we've done it to the benefit of our clients. We've seen an increase in not only just dismissals, but a reduction, as you can imagine. So maybe it's an aggravated burglary, but with the investigator to get out there, it actually is more of a criminal trespass. You might get a conviction still, but it's a huge reduction in harm. And there's also been some cost saving, because rather in the old days where you would have to go beg the district judge, it was out of the realm of possibility to have a misdemeanor judge give you the money for an investigator, but a district judge would, and he or she would give you, say, $250. There you go, find an investigator that was qualified, figure out how to work with them, because you didn't have the education or the training, and you would run out of that money pretty quickly, so you would spend your time as the investigator, and we've reduced that down. The other thing that we've done is we've trained our folks on what a proper development of the case is, and so how to utilize our experts, which has, again, increased dismissals, reduced the harm that our clients are facing and the exposure to the criminal justice system, but it's also shown the prosecutors and the defense bar and the judges what good representation looks like. We have changed the culture, and we're continuing to do it. That's why the holistic defense coordinator has been so important, with not only the investigations and the expert, but more importantly, the social worker. The value of a social worker, and I don't mean just getting your client to their mental health appointments or to any of their pretrial release appointments, but also the forensic capacity of some of these social workers is amazing. To put together a mitigation package, put together something that you can hand the judge in writing, a judge like Judge Brown who really wants to work with you. Give me something in writing, give me something tangible so I can help you help your client. That has been huge. Again, setting the bar a little bit higher, teaching our attorneys, changing the culture, so now that the expectation is this is what quality representation looks like, has been huge, and it continues to grow. Even some of the crustiest defense attorneys who still complain about Cap Ds have turned the corner and are utilizing the resources available to Cap Ds. So also from a defense attorney's perspective, it's a lonely world sometimes that we live in. But having the executive director and the deputy directors who have practiced criminal defense to be able to stop and say, let's strategize on this. Let's set a case strategy where we have some of the best attorneys volunteer their time, come in and sit down, and we just roundtable the heck out of this, figure out how to utilize our resources. Again, we've seen an increase in not guilties. We've seen a decrease in the harm to our clients. and we're changing the culture. I know I'm hammering on that because it's really, really important. We know through the study of social sciences that shame and guilt doesn't effectuate change in behavior. What does is setting the standard and leading by example, and that's what we're doing here. But it is a slow process. What we've also seen with the social workers, and again with the change of the culture, and also change in the fee structure is an increase of pretrial releases. One of the issues that Travis County faces, and up until about 8 months ago, was the highest pretrial incarceration rate across the state. And that seems so ironic with a county that prides itself on being so progressive. But we do have a high homelessness rate, and we do have a high number of individuals charged with crimes who have mental health issues. So there are some people who believe we'll just leave them in custody. With the social workers and with the change in actually paying attorneys for pretrial bond work, we have seen an increase in pretrial releases, and of the attorneys who are billing for their time, it's 76% of those clients are being released pretrial. And a very, very, very high percent of them, almost 70% of them, are actually coming back to court. And we know that the number one factor, the number one determinant in the outcome of a case across jurisdiction, regardless of the defense attorney and regardless of the offense, is whether the person is out on bond. Did I cover it?
Yeah.
And the other thing is the independence of that Judge Brown spoke to, the independence of the defense attorney. So not only am I no longer hamstrung by depending on my relationship with Judge Brown or any judge on how much money I get, because I've now sort of cut those ties. There was a situation, and it existed for 30 years, where you would be, your client might be hurt by how strongly you advocated or how much money you were asking for. And we no longer see that. So we've been liberated from that. And again, I cannot repeat this enough, an increase in the number of not guilties, an increase in the number of one suppression hearings, an increase in pretrial release, and a reduction in the sentences that our clients are receiving. And I think we are a better bar for it. Again, you have some crusty old folks that will begrudgingly agree with me, but change is hard.
And I know I want to turn it over to Phil so he can speak. He hasn't spoken yet, and we don't want to take up the entire presentation, but I feel the need to address one thing, and it's, you know, in my mind, like the big elephant in the room. It was addressed earlier about the bench appointments and so forth, and the numbers might seem staggering. In a public setting like this, I do want to make sure we're not leaving a misimpression. And though the bench appointment rate was like 45%, and now it's down to 1%, I don't want to leave the impression with you that, or with anybody, that judges were just, you know, willy-nilly appointing their friends and things like that, and that's the way why the number was so high. There's a lot of reasons why the numbers were high, and most importantly, judges really, for the most part, are about efficiency, moving the docket and getting, you know, things done in an efficient manner. And so a lot of times the number is so high because there would be cases where a person, you know, may otherwise have a hired attorney, and now they might be in jail. They fire their hired attorney. They're, you know, per se indigent because they're in jail, not working, and so forth. And so now they need an attorney, a court-appointed attorney. And so we're not going to wait 2 weeks to, you know, get that done because they've been in jail for 2 months already. So, you know, we'll appoint somebody right there. So somebody's right there. And there are people, and were people, who made a practice of being around, right? And so, you know, they're just around, so they get a lot of appointments. It's not because you're my favorite person, but you're here. And so I don't want to leave the impression with you all or with the public in general that in the past judges were just appointing their favorite persons and so forth, because I don't think that's a fair assessment. So I have to, you know, speak on behalf of my colleagues in that regard.
Lubbock has the only independent indigent defense delivery system in the state. And let me say that again. We have the only independent indigent defense system in the state. That distinguishes us from Travis County. What happens in Lubbock County is we have a contract with the county. They give us $4.1 million per year and tell us not to run out, and we take care of everything. And we'll talk a little bit about how that works. This office started back in 2008 as a special needs defender's office. We had a problem in Lubbock and a need in Lubbock for people with specialized training in delivering indigent defense services to the mentally ill. So Jim Bethke came to us, and back then we had a young dynamo as our court administrator by the name of David Slayton. And Bethke came to us and said, if this system will work anywhere, it'll work in Lubbock, so let's try it there. So we started the LSNDL, the Lubbock Special Needs Defender Office, solely for mental health needs. We had one situation that really stood out that got this started was a woman who had been in our jail for over 5 years, in and out of the system, in and out of, I didn't finish, in and out of Vernon. She was in our jail for 5 years, or incarcerated for 5 years. She was in and out of Vernon. She would go to Vernon, get restored, come back. She would sit there until she became incompetent again, go back to Vernon, come back to the jail. That happened for 5 years. Once our special needs office was created and she had a lawyer that understood that situation and what to do about it, and worked with our mental health authority to get her medicated and worked with the jail to keep her medicated, she is out of jail since 2009, I believe, and has not been back. That's one of the success stories of the LSNDO. That's what can happen. In 2011, after that worked for a while, we were approached again by Jim with the help of David Slayton. We organized the Lubbock Private Defender Office, and we subsumed LSNDO into that. At that point, the Lubbock Criminal Defense Lawyers Association created a 501c3 called the Lubbock Private Defender Office, and LBDO is a wholly owned subsidiary, I guess you could say, of the Lubbock Criminal Defense Lawyers Association. We handle all felony and misdemeanor appointments in Lubbock County. And as of yesterday, for a population of 300,000, we got our 9,000th case, our 9,000th referral yesterday, just before noon, for the fiscal year that ends, of course, at the end of this month. As far as governance is concerned, we have a 5-member board, which is made up of attorneys within the community, the criminal defense community, who are not on our panel. There are 2 ex officio members. The Lubbock Criminal Defense Lawyers Association president, whoever that may be, is a non-voting ex officio member. And then we have a member from our specialized mental health panel, which consists of about 20 lawyers. That is also on there to address the issues related to the mental health panel. We also have an advisory panel which consists of the presiding local judge, who happens to be Les Hatch currently, 1 county commissioner, court administration, Dean Stanzioni, our court administrator, and 2 local defense attorneys. They are sort of our advisory board. We stay in contact with them. We don't have regular meetings with them. The regular meetings are with our 5-member board. They're the ones that really direct our course of conduct. We started out funding, if I couldn't remember exactly, but I think we started out with about 2.4 or 2.6 million when we started in 2011. Back then, I think we had around 6,500 referrals a year from the county for 2.4 million. As you can see from this slide, fiscal 2016, we jumped to 3.8 million from that 2.426. This year, we jumped to 4.1 million. But we went from those 6,400, 6,500 cases to, as you can see, 9,000 referrals for this year. So the commissioners, we have a great set of commissioners. They have told us that we're not going to fail. Again, they tell us, here's your money, don't run out. But if you do run out, we're not going to let you fail. We have a clause in our contract for extraordinary expenses. We get $4.1 million a year, but if we have something extraordinary, we can go to the commissioners, and we have gone to the commissioners and gotten reimbursed for those extraordinary expenses. One example was a capital murder case. We had a 4-year-old dead child. The client was in a psychotic episode when it occurred. Our office, because it wasn't filed as a capital, it was just filed as, I think, an injury to a child at the time. The referral came to our office. Because of the mental health condition of the client, we hired mental health professionals. We hired a number of other experts to come in immediately and start documenting that case and that client's condition for its ultimate transfer to the Regional Public Defender's Office for capital cases, because it was a death of a 4-year-old. We spent $80,000 on that case before it went to RPDO. And I think Ray would probably agree that the groundwork that we laid certainly helped them resolve that case later. We went to the commissioners and told them, we spent $80,000 of our budget to get this prepared to go to the RPDO. Please reimburse us. We got a check. We have a great set of commissioners in that respect, and great relationship with court administration. They understand our situation, and they react to it in an appropriate way. Our staffing right now, here November 1st, we're going to have a chief defender. I guess I could say I'm what's keeping them from having one right now, because I am the chief defender, as well as the professional development director. That's what I was hired to do. I've been wearing 2 hats, doing 2 jobs since the end of February, and probably not doing either one of them very well. But with Jim coming on, we hope we can take that to the next level. We have a very thin staff. We have an office manager and an assignments clerk. Freddie Tiarina back here from Lubbock County sends David Young, our clerk that assigns cases, sends the referrals to him. David works on a very strict wheel. David Young, our clerk, works on a very strict wheel, assigning those cases out. We have a limit of 65 clients per attorney, not cases, clients, because one client may have 20 cases, the way things work in Lubbock. So we limit it to 65 clients, and we monitor that. Once they get to 65, they're put on hold. So we run it doesn't take a big staff to run an office like this if you're concerned about administrative cost. You see our $718,000 in administrative costs from last year. A lot of that's taken up by the 4 caseworkers that we have, about to be 5 caseworkers that we have that deal specifically with our mental health caseload. We have, as of the other day, we had 260 clients in our special needs section, and that's a pretty heavy caseload. We figure that about 45 per caseworker is adequate. They're way over that. So the commissioners have agreed that we get another caseworker this year, but a lot of that is taken up with that particular side of the office. Our wheel, we actually have 8 wheels. I think Travis County is very much like that. We have a first degree wheel, which out of 80 lawyers is about 11 lawyers. And that keeps their caseloads fairly high, but not over that 65. We have, of course, if you have a law degree and a pulse, and you're upright and breathing on your own, you can be on misdemeanor 1s. That's for you guys coming out of law school. And those guys are very carefully mentored in the early days, because even the most benign misdemeanor, Class B misdemeanor, can have some collateral consequences. So we watch those, but we try to get them the trial experience and development that they need to move on up as they're able. We have a number of things that we do in Lubbock County. Again, we have a very strong criminal defense bar and always have. Not sure why, but we always have had a very strong, cohesive criminal defense bar. And let me have an aside here. That helped us get this started. Again, Jim told us when we started these programs that if it's going to work anywhere, it's going to work in Lubbock, Texas, because of our defense bar. That's not to say that you can't create one of these in a defense bar that's not as strong and not as cohesive, but it does make it easier. I think, as Kelly may have pointed out, having one of these makes the defense bar stronger and more cohesive once it's started. But again, that's kind of an aside. We have a strong, long-lasting relationship with the Texas Criminal Defense Lawyers Association, and as a result, we get our Prairie Dog Seminar in January of every year, funded by the Criminal Defense Lawyers Association out of the funds that they get from the Court of Criminal Appeals. It's actually probably the second largest seminar TCDLA puts on behind Rusty Duncan in San Antonio, their annual meeting. We do it at the law school. It's pretty much required attendance. We require a minimum of 12 CLE hours a year to be on our wheel. And we can get that through that Prairie Dog Seminar, and everybody tries to make that. We also have monthly CLE meetings along with our Lubbock Criminal Defense Lawyers meeting. You can get at least 30 minutes and up to an hour of CLE a month at that. For our mental health attorneys, we require an additional 8 hours of mental health specific CLE each year. As a result, we put on 10 hours of CLE throughout the year at the courthouse for that specialized mental health wheel on mental health topics. We created last year what we call a trial college for practitioners that have been in practice for less than 5 years. Once a month, we take a topic: voir dire, plea bargaining, use of PowerPoint during voir dire or trial, cross-examination, direct examination, opening, closing. We've taken one of those topics each month and required our younger lawyers, our 5-year or less practicing lawyers, to come in and be a part of that. We have also taken from the medical community what we call the rapid response team. In the medical community, if a nurse has a patient that's not responding to treatment or they're having some heartburn about, they can call a number and a rapid response team comes in. If a lawyer has a case that's given them some particular heartburn, if they want to brainstorm, they call me. I put together a team. We come together at 5 o'clock in the evening. These guys come in on their own time. They volunteer to come in, and we sit around and brainstorm that case for at least an hour. And we've done that on more than one occasion on one case in order to get them ready for trial. We found it to be very productive and also often settles the case or leads to a settlement. Friday lunch mentoring. We've again taken our younger lawyers without a lot of experience and contacted them one by one. I went through it yesterday. I think we've got 11 or 12 that I will email them and tell them to pick at least 3 cases, 3 random cases from their files, grab their lunch and come and meet us. There are 4 of us that meet with these young lawyers Friday at noon. And when we first started doing it, they thought they were coming to the principal's office. They thought they were in trouble. But once the first one came and realized that it really helped, he put the word out around the courthouse and, hey, this is cool. You really need to do this. Don't worry about it. So it's becoming popular, and we plan on offering it to other more advanced lawyers as well. It's just a good way to mentor these lawyers in the cases that they may need just a little bit of help or push on. Second chair opportunities, I don't know if y'all have the same experience. It's difficult to get people to trial these days. We don't have as many trials as we used to. So second chair opportunities are not as often as they used to be, back in my day, I guess I could say. But we try to, nobody goes to trial alone. That's our motto. Nobody goes to trial alone. If you're going to trial, you're going to have a second chair. It's going to be generally a younger lawyer, less experience. You can carry wood and water for you, but you're going to have someone with you, and that whether they're sitting there like a bump on a log or they're actually participating in the trial, they're getting some exposure to the courtroom. They're getting that courtroom experience, so they'll know where to sit and when to stand and when to sit. Because trust me, some of these guys with the law license and the pulse don't even know that, and they need that. Episodic mentoring, that's most of what we do. We've not had much success with saying, okay, Kelly, you get with so-and-so and you're that person's mentor. I want you to have lunch every month and talk about cases. That has not worked well for us. Episodic mentoring means that if I'm standing around the courthouse hall and someone comes up to me with a problem, then I'm there to mentor them with that problem. And that goes for all of our senior attorneys. Our senior attorneys have the charge that if they see a young lawyer in front of the bar about to walk into a propeller, then they've got the permission from me certainly to step across the bar and pull them back and say, wait a minute, let's think about this. What are you doing? And then when that happens, I will generally get a call and say, you know, we need to work. We need some help. Again, we have a budget. We get money, and we're told not to run out. If a lawyer this morning has a guilty plea, and they go back to their office and they submit a voucher, we get that voucher immediately. It's usually printed off and handed to me. Very often, it's approved by the end of the day, and no later than the next morning, that lawyer will have a check. It's that quick. The lawyers absolutely love it, and rather than cutting a check, we're talking about moving to automatic payments, so it'll be even quicker for them to get their payment. That's just one of the advantages that we have, I believe, over the hybrid system. But again, we're a lot smaller. We can do that. Attorney performance monitored in several ways. I go watch these guys try cases. I will actually sit with them when I have time to try cases. Through the mentoring programs that I discussed earlier, input from judges. All the judges have my cell phone number. If they see a problem that needs to be taken care of immediately or later, they're not bashful about emailing, calling me, texting me, saying, come see me. Input from fellow lawyers. Often I will get an email from a note from another lawyer, an elder lawyer, that will say, you might want to talk with so-and-so. I saw him in court this morning doing this. You might want to address it. If I'm getting a lot of letters from the jail saying my lawyer hasn't come to see me, I have the ability to do an open records request and see if it's the lawyer that's not doing their job or the client that's lying to me about how many times they've seen their lawyer. We have a number of ways of monitoring that. The last thing I want to say is that if you're debating whether to have a public defender's office, or if you already have a public defender's office wondering why you need one of these managed assigned counsel programs, it's because they're not mutually exclusive. El Paso has a great public defender's office. Dallas has a public defender's office. Harris County. You're going to have conflicts, and they have their limits on the number of cases they can take. The MAC can be can augment your public defense system by being in the hands of the private bar and handling things the way that we handle them. And I'm way out of time. If you have any questions, I'll be around all day.